All right, well, thank you everyone for joining us today. This webinar will be recorded, and as always, if you have any questions throughout the presentation, please just type them into the question box and we will do our best to address all of those at the end of the presentation. So just some housekeeping before we get started. These webinars are intended for educational purposes only. We hope that you learn some new information. However, the trainers presented in these webinars are not attorneys, so all information provided during the presentation and during the Q&A session at the end should not be construed as legal advice. All right, so now that we got that out of the way, good afternoon or good morning, depending on where you're sitting. My name is Adina Glencher, and I would like to welcome you to our webinar today, where we will be talking about creating an effective employee handbook. So like I said, if you have any questions, just jot them down or type them into the box, and we will address them at the end if time permits. If time does not permit, you can go ahead and write down my email address or my phone number and give me a call or shoot me an email at the after the presentation, and I can address those questions. And if you chose to ignore that, that's okay too. My email address will be at the end of the presentation as well. Okay, so now let's jump in. So today we are going to be discussing quite a bit. We're going to talk about what an employee handbook is, components of an effective employee handbook. We're also going to talk about examples of legally required policies, as well as examples of recommended policies, the top 5 handbook mistakes, and should you update your handbook in 2022? Well, we will find out. And then lastly, we will end with a Q&A session. All right, so before we start talking about specifics regarding the handbook and what's inside of it, I want to begin talking about what an employee handbook is and its purpose for employers. The number one way to ensure your handbook is effective for your business is to understand its purpose in your business. So let's start with what an employee handbook is and why you need it. An employee handbook, put simply, is a resource for an organization's employees. That's it, very simple. And it's a tool to help you communicate to them. So why do we need this tool? It allows you to clearly communicate your expectations of employment. Obviously, when we first hire somebody, we hire them because they probably went through a great interview process, and we think they're going to be a great fit for our organization. Well, in order to ensure they're a great fit and in order to ensure they succeed, it is so important that we outline our expectations of what it means for one of our employees to succeed. It also allows you to demonstrate your organization's culture and your benefits. So it allows you to communicate the type of people your organization hires, what you offer to retain top talent. In addition, there are a lot of studies that show that millennials and Gen Zers are most interested in their employer's values and mission, more so than any other generation before them. And because these generations are going to be making up a lot of the workforce in the next few years, actually a majority of it, it is important that we highlight those cultures and those benefits in your handbook. So let's highlight what you offer and what sets you apart. Of course, it informs employees of their rights. And it definitely acts as a protection for employers as well. It shows that you clearly communicated your policies and your employees' rights to them, and do so will make it easier for you to actually hold them accountable to those policies. All right, so we covered what a handbook is and the purpose of it, so let's dig a little bit deeper. All right, so I'm going to pull up this diagram and we're going to talk through it. But before we jump into it, I want to talk to you about the two different sides I have here. So you might be surprised to see that employee handbooks are not actually legally required. So you might be wondering why we're here today. You do have the option not to have one. However, you're still legally required to comply with state and federal laws, regardless of whether or not you have a handbook. And it can be very difficult, as I previously said, to actually enforce undocumented performance or attendance-based policies because they're not mandated by state or federal law. So it is important that your handbook outlines those things. So for the purpose of our presentation today, we're actually going to be talking about the right side, which is those of you who choose to have a handbook. It is important to know that if you choose to have one, you are legally required to follow the policies in your handbook. And you must include legally required required policies both on the federal and state and sometimes local level. And it is highly recommended that you update your handbook annually as state and federal laws change and policies will quickly become outdated. All right. So what do these policies look like? Components of a handbook. There are a lot of laws that both the federal government and individual states mandate that must be included in an employee handbook. These make up the legally required policy. So I just listed a couple examples on this slide for the sake of space, but we will go into a few more. And the ones we discussed today are not all extensive. So examples of legally required policies include an AtWill statement and a reasonable accommodation policy. It is your responsibility as an employer to inform your employees of their rights and provide this information. Next, we have recommended policies. So although these are not legally required always, they are highly recommended and will help avoid common employee relations issues and just misunderstandings. So a couple examples of these include an introductory period policy, a conflict of interest / employment of relatives policy, and we'll get into that later. And then of course there are some more. And then lastly, in an employee handbook, you can include your unique company policies and benefits. So this is a section of the handbook that actually allows you to communicate benefits, set expectations, and demonstrate your company culture. You can see, some examples provided here include student loan repayment, floating holiday, health and fitness stipend. Maybe you offer a work from home benefit or anything you may offer that will set you apart. It allows you to show your employees why they should work for you, what benefits you would offer them. All right, so we're going to dig in first and foremost to those legally required policies, those that have legal notice requirements to include in your handbook and to ensure compliance. And like I said, this is not going to be an all exhaustive list, but it can give you a general idea as to why some of these key policies need to be in your handbook. All right, so first we're going to talk about an AtWill notice. So I get a lot of questions on this, and generally it's when a client calls and they want to terminate an employee and they say, why can't I terminate them? We're in an AtWill state. I don't understand why you're not recommending it. So I do want to provide some clarity on an AtWill notice and what its purpose is. So generally it means that the employee or the company can terminate the relationship at any time for any reason with or without notice. However, with every termination comes some level of risk. So it is important to note that you still need to have your ducks in a row before terminating an employee. So this is a very blunt way to put it, but in my opinion, it's the easiest way to explain it. Yes, if you are in an AtWill state, you have the right to terminate your employee at any time with or without notice. Your employee still has a right to sue you. So an AtWill notice doesn't protect you from being sued. Therefore, if you have one, if you're in an AtWill state, it's important that you still have your documentation in place, that you've had performance conversations with your employees if it's about performance. If it's not about performance, that it is either severe or severe enough to warrant termination. All right. And a lot of people, just touching back on the AtWill notice, will ask, well, what's the point of having one? An AtWill notice, it's legally required for you to tell your employees that you are in that state and that they can resign at any time too. So it helps mitigate the risk of them assuming they're in some type of employment contract or agreement. All right, another policy is the Equal Employment Clause in the ADA accommodation statement. So these statements provide notice to employees that you follow non-discriminatory hiring and employment practices. You may also see similar statements like this on job postings, on employment applications, and even on job descriptions. That's because there's truthfully never too many places to put these types of notices because of the severity of violations. So additionally, the ADA statement should also include an accommodation notice of internal processes, meaning you need to provide employees with a general idea of how to go about requesting an accommodation should they need one. If you don't have a process in place or you do not notify employees of their rights and ability to request an accommodation, you're technically not in compliance with the ADA. So that is important to consider. And then I just like to point out a few facts. So you can see in the slide that in 2008, 20.4% of all charges of discrimination filed with the EEOC or the Equal Employment Opportunity Commission alleged disability discrimination. And that percentage has increased every single year since 2008. And in 2020, disability claims made up 36.1% of EEOC charges filed. And just by way of comparison, race discrimination charges decreased by 3% in that same time span. So it is just so important that you are telling your employees that they have rights, you're explaining these rights to them, and you are providing it to them in an easy way for them to access it at all times. All right, employee classifications is another big one that often gets left out. So this section is required to be compliant with the Fair Labor Standards Act, or the FLSA, and properly classifying your employees is a huge compliance piece. Employers are legally required to notify employees of their employment status and what that status means. So we need to make sure we're explaining it to our employees. So, you know, are they exempt? Are they non-exempt? And what do those definitions really mean, or those words mean, excuse me. Many employers include the status notice in an employee's offer letter, which is great, but typically that notice does not include the classification, so it's important to have that in the handbook. Additionally, employers should avoid making up any classification. So I have seen a few handbooks where companies will make up a classification that does not exist. If they're not recognized by the FLSA, then they should not be in your handbook. We should make sure that they are recognized definitions. And one additional benefit to having this outlined in your handbook is that it creates a tool for your employees to understand their classification and their benefits. So rather than having a bunch of questions to you or your HR department about what level of PTO they fit in or whether or not they qualify for overtime or holiday pay, it is explained to them in their handbook, and they are able to better understand what policies actually apply to them. All right. The next policy we're going to talk about is the lactation accommodation policy. So a lot of employers get confused by this because they assume that this ties in with FMLA or pregnancy leaves, but in fact, it is a policy on its own. I have seen many handbooks that do not include this policy, and it is legally required. It is required by federal law as well as by many state laws, which we'll talk about in just a minute. And that includes both the break time and the location for the nursing mothers to take place. All right, so this may be expanded, by certain state law requirements. So some states such as California, New York have additional requirements apart from what the federal law states. So it's important that we are following the most strict law, whether that's federal or state. And then accommodations generally must be made for up to 1 year after a child's birth. I recently have seen a few states extend that to even 2 years after a child's birth. So it's important that we're staying on top of our state laws and of course our federal laws to make sure that your handbook policies continue to be compliant. All right, and next, the very popular sexual and other forms of harassment prevention policies. Included in this is discrimination and abusive conduct, violence, and etc. A lot of employers get confused on this one because harassment has a lot going on at the federal and the state legislative levels. So we're going to break it down a little bit. Sexual and other forms of harassment are illegal under federal law. However, federal law does not actually require a policy on harassment. State laws often do require a policy. However, regardless of whether your state requires it or not, courts have been shown to favor employers with a policy and training in place for harassment. So what that means is that if you have a policy and harassment training in place, there is actually evidence that the company took good faith measures to prevent harassment and will be more likely to reduce costs of harassment claims depending on the claim. Basically, these are preventative measures against harassment from occurring as well as from the claim damage. So another thing to keep in mind is that not only do some states require that you have a policy, they actually require that you train your employees as well. So it is important that you are familiar with what states you operate in or your employees work in, and whether or not there are harassment training requirements in those states. For example, California, you need to have employees complete harassment prevention training for all employees every 2 years and within 6 months of your new hire's hire date. And if you need to get any training done before the end of the year, you can always reach out to me at the end of the webinar. We can talk through how Pay Entry HR Services can assist you with that. All right. And then lastly, we are going to very briefly touch on state laws. These vary by state, and employers need to be aware and familiar with what leaves are required in their states. So we're just going to talk through a couple examples. Volunteer firefighter leave, veterans leave, sick leave, civic duties leave, which can include witness and jury duty leave, and then state-specific medical leaves are just some examples of some state-required laws that need to be put into your handbook. If you are a multi-state employer, don't assume that the laws you use for one state are compliant across your company, because that may not be the case. And for all of these state-mandated leaves, employers are required to provide employees notice of their rights to take this leave. It is your obligation as an employer to inform your employees of what is available to them to take protected time away from work for any of the reasons dictated by your state or local legislation. All right. And then considered a benefit should be included in the handbook to be compliant. So typically these are considered benefits, and it's important that we are telling our employees of them. So if you have questions about any local laws or state-specific laws, reach out to me after the presentation and we can set up a time to discuss that. All right, so we are moving away from the legally required policies, and we are going to cover some recommended policies. And this is, again, not an all-extensive list. So the first policy is an introductory period policies. You may know it as a probation period, but we have moved away from that language because of its negative connotation. Essentially, the introductory period is a set amount of time. It's usually about 90 days, where an employee is getting their feet wet with the company. The new employee will be familiarizing themselves with their role, their team, their manager, and any tasks involved in their position. Now, a lot of employers assume that the introductory period is the time when they can exercise their at-will doctrine at any time during the 90 days. Even during those 90 days or during that introductory period, there is still a level of liability with any termination. So documentation is still highly recommended. And it's important that somebody within their 90 days is not just terminated without cause or without notice, and that they are made aware. I always tell clients a termination should never be a surprise. Either A, the employee has been talked to multiple times and the issue continues to happen, there's not any improvements, so they know termination is on the way, or B, they've done something so egregious that it warrants termination immediately. And if that is the case, they should know they did something pretty bad. So what does this policy do if it doesn't allow us to just terminate somebody and kind of negate that at-will clause? It outlines expectations for the first 90 days of employment and notifies employees that their performance will be monitored during that. It also allows a great excuse to conduct a 90-day review. So I think that not only should annual reviews be done, but a 90-day review is always great to ensure that your employees are meeting expectations early on, and that you can, if there are any training or performance gaps, you can have those conversations quickly. All right, next we have conflicts of interest. So what I did is I kind of combined a few policies here because they often are called different things or kind of go hand in hand. So the first topic we're going to discuss under the conflicts of interest umbrella is an employment of relatives policy. So I realize that many small to medium-sized businesses tend to have family or tend to be family owned, and so they tend to hire a lot of relatives. Studies have actually shown that family-owned businesses are taking advantage of more by family members than by non-relational employees. So this is why I recommend that a lot of family-owned businesses have some basic guidelines in place surrounding hiring additional family members into the company. So these guidelines can be customized to your unique business, of course, and needs and structures of your company, but some basics should include that family members will not manage other family members directly. And family members will not be placed into roles that create a conflict of interest. So what does that mean? If you're a family-owned company, it may not be in the best interest of your employees and company to put your family member in an HR or a payroll position. That in itself just might create a conflict because HR and payroll tend to be pretty controlling and involved positions that may affect both family and non-family employees. So you want this person to be impartial and a neutral party and able to represent all employees equally in their duties. All right, so the next topic that I want to discuss, and it can be under the conflicts of interest umbrella, is outside employment / moonlighting. All right, so what is this? This policy generally outlines the employer's request of employees who hold another job. It is important to note that in most states, you cannot actually require that you approve an employee's second job. What you can do, though, is you can have a policy in place that states that no employee can have a second job that interferes with their ability to do their initial job for you, and that no employee will have a second job where an actual or perceived conflict of interest is occurring. So an example of this might be working for a client or selling the same service for your company that your company sells. So if you're a payroll company, you're not going to have your employee can't work for another payroll company because that would be a conflict of interest. And they of course cannot work another job whose schedule interferes with their current job because they have to be able to get their initial job completed. All right, next policy we're going to talk about is the complaint procedure or grievance procedure policy. So a lot of employers assume that having an open door policy is the same as this, and it is in fact different. I highly recommend everybody have an open door policy, which shows that you are open to hearing about your employees' concerns that they may have about the company or while at work. But this policy, it gives employees a specific avenue and process to follow when they need to file a complaint. So you might be thinking, why do I want to tell my employees how to complain? Well, for one, it allows your employees autonomy to look up the process and follow it themselves. So they don't feel lost if there is an issue. And two, employees have the right to file a complaint with the DOL, the Department of Labor, OSHA, the EEOC, or their state-specific regulatory agencies, of course, a private attorney. And they can do all that without talking to you first. They don't technically have to go to you. So if you have a process in place that explains how your employees can express their concerns internally, they are less likely to go to these regulatory agencies, which allows you to handle it internally, which may very well mitigate your risk because you probably have processes in place to solve this. And if you don't, you can reach out to your HR professional and talk through, different strategies and how to help solve these issues. So we want them to know how to complain if they need to. All right. Next, another important policy to have clearly outlined is a progressive discipline or corrective action policy. This policy outlines how performance or behavior-based issues will be addressed in the company. So I laugh a little bit at this policy because it should not outline what performance or behavior issues will be disciplined. So it needs to be vague but specific, which I know is probably as clear as mud. So the policy should be clearly outlined but ambiguous enough to allow for discretionary decision making. So it's important to tell your employees, hey, we have steps to address performance issues. They might include a verbal warning, a written warning, a final warning, and up to including termination of employment. But we don't want to list out all the possible infractions and what they will lead to. There's a few reasons for this, but the biggest reason is that, one, things may change. As much as it is important to be consistent, there are situations that need to be handled on a case-by-case basis. And two, none of us are perfect, and we can never outline every single behavior and what that should lead to. So if a behavior is not listed and it occurs, maybe an employee brings a weapon to work and that's just something we never thought would happen, so we didn't include it. It's going to be very difficult to issue any disciplinary action because it's not on that list. So we want to have a process, but we don't want it to be outlined for every single infraction. All right. And then a newer recommended policy that we're seeing, or I should say have seen, I'm sure you all have one at this point, pop up in the workplace is the work from home, telecommuting, telework, however you want to call it, policy. So these policies outline any expectations for employees that are permitted to telework and under what circumstances they are able to do so. Often the employee handbook will highlight the benefit, who it's available to, and then the employee will actually be provided with a separate agreement that goes into further detail about safety, distractions, expense reimbursement, etc. So we want to put some detail in here, but it can get extensive if we put all aspects. So a separate agreement is often recommended in this situation. When creating this policy, it is important to establish clear guidelines for eligibility if you're not going to allow all your employees to telework, or if it's only available for some positions. And these types of work arrangements should get managers or human resources approval. And lastly, if you are not a 100% remote work environment, then it is a benefit and should be construed as one, unless of course it is provided as a reasonable accommodation. All right, so we made it through our legally required policies, just some of them, and some of our recommended policies. Now I want to talk through the top 5 handbook mistakes. All right, first and foremost, not including a mission, vision, and value statement. So many employers don't have one or don't even think to include one, and this section is incredibly important. Other than during the interview with this employee or your new candidate, I should say, this is the first impression your employees will often have of your company. So these sections allow you to include personality and culture into your handbook. Tell your new hires what your company stands for, what your values are. Why do you do your business the way you do? Why'd you get into this business? What are you passionate about? Do you admire hard work, integrity, honesty, and being a team player? Great, but how do your employees know all of that stuff? And how do you know that you are attracting that type of candidate with those values if it is not obvious? So your mission, your vision, and your values need to be on your job ads, in your handbook, your LinkedIn page, your Glassdoor page. In order to get started, I recommend that you at least put your core values into your handbook. If maybe you don't have a mission, vision, or value statement, you just don't have time to come up with one, list some of your core values so your employees know more about you and your business. All right, second, when your policies don't match what you practice day to day. So this is a huge issue and can cause a lot of legal trouble for employers. I always tell people it is better to not have an employee handbook than to have one and not follow it. So I can't tell you how many times I've worked with a client on their handbook and quickly find out that they no longer practice what their handbook says. Maybe it was written 10 years ago, maybe it was written 1 year ago, and they, changed half their policies or adapted them a little bit. So your employee handbook must be followed as if it were the law and outline all of your benefits so they are easy to understand. All right, next, when managers and supervisors are not trained on the employee handbook. So this pretty much goes with the above one. Your managers and supervisors should be setting an example for your employees, and they should be able to answer questions. So if they're not familiar with what's in the handbook, they're not able to practice and enforce it. Consequently, there are legal ramifications when managers inappropriately respond to certain situations. So it is important to remember that it is not just human resources responsibility to ensure employees are following policies, but this should be a large responsibility of your managers and supervisors as well. All right, fourth mistake, failing to adequately distribute and document acknowledgements of the employee handbook. So a handbook is a great tool, but it's not a great tool if it's sitting on your shelf getting dusty for the last 10 years. The employee handbook is only fulfilling its purpose if your employees know it exists and it's being used. Therefore, the handbook should be provided to each employee at the time of hire, and made available to them wherever it is easily accessible. So whether that's online in some type of employee website, or whether that's they each have a hard copy, whatever you choose to do. In addition, they must sign a form acknowledging that they actually received the handbook, they read it and understand it, and agree to abide by the policy. It may seem like a no-brainer that this form should be signed before they start their first day of work, but I've definitely seen businesses where they wait until 2 to 3 weeks into the hiring process for them to sign the acknowledgement. Then in that case, there are really no grounds to hold them accountable prior to the signing of the handbook. So it's important that to reduce your liability, it is provided to new hires prior to being onboarded or on the first day. All right, 5th, omitting legally required policies or having illegal policies. So I think this one is pretty self-explanatory, but it is so crucial that the policies in your handbook are legal and that you're not putting any illegal verbiage in your handbook. So this is why updating it is important. I recommend you update your handbook every year, depending on what state you're in. This may be more crucial, but things are changing constantly, and your benefits might be changing, and your unique policies as well. So it is important to have everything in your handbook that you legally are required to notify your employees of. Okay, should you update your handbook? So we're almost at the end of the presentation, and you might be asking yourself, all right, I already know it's supposed to be an employee handbook, or I just learned what's supposed to be in one. I already have one. Do I need to update it? So really think about these questions. Have you updated your handbook in the last year? A lot has happened in the year, and a lot has changed in our world. Do we practice our policies as they are written? Do I have handbook acknowledgements from all of my active employees? So you can easily, pull up 20 or 10 personnel files and audit this. If they don't all have a handbook acknowledgement from the most recent handbook version, then it may be time to update your handbook. Has my city or state had any legal updates in the last year? Have I hired an employee in a new state? This is a big one. Have there been any significant changes to my employee count since my last update? So maybe you started your business a couple of years ago with 5 employees and you're now at 55 employees. That is going to change what is legally required in your handbook. Or maybe you did a mass layoff and you only, you had 80, now you have 20. Any changes in your employee count may affect the policies required in your handbook. And have there been any major benefit policy or cultural changes since your last update? Did any merger acquisitions happen? Did you change your health insurance policy? Does that need to be updated in your handbook? So these are important questions to ask yourself, and we can absolutely help you update your handbook or create a handbook if you need support. All right, so lastly, we are here to help. I know that business owners or managers have a lot on their plate, so let us take the burden off of you. Our team can assist you not only with your handbook, but really any HR need or request you may have, including updating your job descriptions, COVID-19 compliance, performance discipline process, employee relations, and much more. So I told you I'd give you my email address and my phone number one more time. Feel free to write that down. Any questions you have or you're interested in our services, reach out and we will do our best to assist you. All right, so now let's get into some questions that may have come in during the presentation. Kathy, I'm going to call on you to join us, and will you let me know if we have any questions?
We do not have any questions, Adina. It looks like you answered them all while you were going through there, or either you have stunned people. So just know that you can send us a question after this to hrservices@payentry.com or to one of us individually, and there are no questions.
Okay, well, if there are no questions, I thought that might happen. I put a couple on here. 2 questions that I get asked all the time. Do I legally have to have an employee handbook? I'm starting with the second one. The answer is no, you do not, but if you have one, you have to follow it. And should I include a COVID section in my handbook? Surprised that question didn't get asked. So you should absolutely have COVID policies, but we don't recommend you necessarily have them in your handbook. And we could tell you more why if you want to follow up on that. But Like Kathy said, thank you all so much for joining us today. Let us know what topics you want us to focus on in future webinars, and we hope you have a wonderful rest of your day.